Chris Bentley, and I'm with Johnson Jackson. And I do want to give another shout out to Kelly and her team. I know they've been very busy over the last few weeks, trying to make sure all of our members are staying informed with the latest news, policies, ordinances, laws, and everything that's going into effect. I know it's, as Kelly said, it's changing every day. I mean, just this morning, the IRS did another publication. So that gives a lot of Q&As to employers, which we'll talk about. That's very helpful for their organization. I do want to remind everyone that we are in a Zoom meeting today. And so that means if you're showing, there's a video option so people can see what you're doing. I know there's been a lot of funny stories going around about the various Zoom meetings that have occurred. I was personally a victim of it on last Friday. I was on a Zoom meeting and my 3-year-old daughter, AKA my new coworker, decided to barge in the room and proclaim to everyone that she needed to go potty really, really bad, and then ran into the bathroom with the door wide open for all to see. So I get it. It's just a new way of norm for a while. But as Kelly also mentioned on this Zoom, there is a place for live chatting. If you ever decide to need to go ahead and write a question down, go ahead and do so. I will do my best if I can to address it during live time. Otherwise, we can get back to it during the Q&A. So as you know, we all are experiencing some challenges, challenging times due to this COVID-19. And it has created challenges not only for our businesses, but also for our employees. Each day, companies are having to face really tough choices. New laws, regulations, and ordinances are being passed, and new measures are being taken by our federal, state, or local governments. To help navigate through some of these changes, I want to focus today on the Americans with Disabilities Act. I want to talk to you guys briefly about layoffs and furloughs, the Fair Labor Standards Act, WARN Act, briefly to extent it might apply to some of you all, and then obviously the new Coronavirus Response Act. But before we address any of these things, I do encourage everyone to start thinking about the framework for this, the frame for your decision making. As you make these decisions about your employees, you really need to be thinking through what your decision making framework is. How you think about the crisis is really going to guide your choices. And that's what I've been talking to a lot of clients about. So let's talk about the big picture before we get too far into this. The big picture starts with the immediate future. When a lot of us think about the immediate future, we are thinking about survival. How are we going to survive this crisis? That is a natural way of thinking about it. But when you're thinking about it in that way, you're taking a very defensive approach. You are addressing how do we minimize damages? Are we taking reasonable steps to ensure that we're complying with labor or employment laws? But if at the same time, we can also switch over to a growth mode and think more about this constructively, we might be able to weather this storm and position our businesses in a better place once everything passes. My partner, Kevin Johnson, recently reminded me of a quote from Joe Kadow, who is the former general counsel for Bloomin' Brands. And Joe always said, never waste a good crisis. We are in a crisis. We all know this, but this may be the opportunity for you and your business to really shine. It's an opportunity for your company to survive and to show something to your employees and the community that are going to be important to them in the future. Think about this in terms of service and the bonds that you can build with the service. Think about service to your customers, service to your community, and service to your employees. As we're going through this, I'm going to encourage you to always make sure that you're communicating with your employees. Let them know what is going on. It's okay that you might not know all the answers or that you're going to do your best to get through this. Employees want to hear the truth. That information is valuable to them, even if you're not going to be able to provide them with the same paycheck or the same number of hours. So let's think about the near future. How is your organization going to pivot once we get out of this? How are we going to get your business in a position to accelerate out of the term? What does this mean? Are you going to need to think about employee retention? Ideally, you would like to keep your best workers. We want to keep the most talent that we have, because we don't want to position ourselves when we get in the time, when the time comes, when the guidelines are lifted, where you're going to have to go out and try to find new quality workers. You also don't want to be in a position where you have to train all these workers and get them on board, because right when that guidelines are lifted, you're going to want to hit the road running. You also don't want to be in a situation where you face a bunch of lawsuits, because that will take up your time, money, and quite frankly, it'll disrupt your growth. So for the long term, what are we going to think about? Well, we're going to think about the fact that other employers, unfortunately, are going to have to shred a lot of their workforce. So the market is going to be switching overnight, and from a very constrained market where we were only able to, it was difficult to find good, attractive talent, to a marketplace now where there's going to be a lot of quality workers out there that you're going to want to attract for your business if there's a need to do so. And the way to get that, to attract those workers, is to develop a really good culture for your business. You'll need to remember, though, that people, whatever your actions now and the decisions that we're going to talk about, they will affect that culture. People will be watching, employees will be watching, and that word will get spread around to all. So be mindful of all this framework when we go through this stuff. It's kind of big picture stuff, but I do think it's just kind of important to address, because I do think it will help shape some of your decisions for you all to do the best you can given these very trying times. So the first thing I want to talk to you all about is the Americans with Disabilities Act. And the ADA has recently issued out some more guidance regarding the pandemic that's going on. And from the screen, as you can see, that is the website where you can get some of your questions answered. But I do think the most important thing that we address is some of these questions that I think you guys will face on a more normal basis, or will commonly face right now. Obviously, safety is our #1 priority, and we are going to be focusing on safety as much as we can to make sure our workers are protected. So some of the questions that might be asked, so is one, may an employer take its employee's temperature to determine whether they have a fever? And the simple answer is yes. Employees are able to do this during this time. If we were dealing with, the seasonal flu, my advice here would be different. And I would say, no, you're not going to be able to do that. But since we are dealing with the pandemic, EOC has stated that employers can go ahead and take the temperatures of employees. If an employee exhibits a fever, then the employer can send that employee home. But as you all know here, that the virus may be asymptomatic for some of these employees that are not experiencing fevers, and they can still subject our workforce to this virus. Next question. When an employee returns from travel during a pandemic, so for example, if someone just recently came back, let's say from New York, must an employer wait until the employee develops symptoms about his or her?
Kelly, I'm sorry to interrupt you. We're getting some messages that they can't see past the first slide.
Oh. Let me see.
I know that Zoom, because so many people are on the internet and so many people are using Zoom, I know that Zoom itself has had some challenges recently.
Let me see if I do it again. Let me share it again, see if it works. If not, I can just send it. I can send it to everybody afterwards.
Okay.
Can you all see that? Is everybody?
I can see that, yes.
What about if I do that? Can you see if I
Yep.
switch it?
Yep.
Yes.
All right. So let's try that. And again, if anybody, just chime in if you can't see anything, please do. So where I left off is if someone is traveling from New York and they just got back and the employer's like, I don't feel comfortable bringing this employee back right away. Can you do that? The answer to that question is yes, you can. You can prevent the employee from coming to work. You can tell that employee don't return for 14 days until he or she is pretty much self-quarantined. And during that time, the employee, and you're doing that because you believe that employee poses a direct threat to your organization. Okay. When that employee's out, he or she can use PTO if they have it available, or they can be out unpaid. And we will talk about a little bit later whether that new law will apply to that circumstances. Let's go to the next one. May an employer require employees who have been away from the workplace during a pandemic to provide a doctor's note certifying fitness to return to work? And the answer is yes. We can require employees to come back with medical documentation showing that he or she is able to work and maybe is not affected with the virus. Now, I think we all need to be very practical about this though. the doctor's office are getting flooded with people coming in, and it's very hard to get in front of a doctor. So if your policy, for example, states that you need a written note from the doctor with his signature, yada, 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 well, that might not be, you might need to lax that requirement. Maybe a phone call is sufficient, or maybe a simple form that the doctor's office is using that provides to the employee, that should be sufficient. But yeah, you can still continue to apply that, because obviously we're doing safety is the most important part of this. Next one. May your employer require employees who are not suffering from symptoms to disclose whether they have a medical condition that would make them vulnerable to complications. The answer to this one is no. We cannot make these types of inquiries are impermissible, especially if you're asking an employee to disclose a compromised immune system or a chronic health condition. However, one way around it is if the employer makes an announcement to his staff and says that if any employee has any concerns regarding COVID-19, that the employer will be happy to engage in the interactive process and see if there's any reasonable accommodations that we can, talk about. In that situation, the employee then might say, hey, I do have a compromised immune system. I would like to work from home, if that's something we can do. And if we can do that as the employer, given the role or the duties that that employee is performing, then we need to look into it. Now, those are probably the main ADA stuff that you're going to see on a common basis given this pandemic. I know OSHA has recently provided some guidance for employers. This guidance will assist employers to allow them to ensure that they're having safe business practices. The publication primarily focuses on most of the obvious things, such as social distancing, washing hands, and teleworking. It encourages employees to direct employees that are feeling ill or experiencing symptoms to refrain from home. But you all know that. I mean, that's been preached on every news publication that we see. It also does provide recommendations in here if you are one of the industries that are high or moderate exposure. It talks about wearing protective personal equipment and stuff like that. So I do encourage you all to check that out. Most of the businesses, however, are going to not be the high or moderate exposure industry. That's going to be obviously the healthcare professionals, first responders, and things like that. But for other businesses, we're going to be more on the lower level, but it does give you some guidance to follow. So let's switch gears though, because I think we really need to talk about how this pandemic is going to affect operations and the decisions you're going to need to make on that level. The first law that we're going to talk about is the Fair Labor Standards Act. And this is the one that when we start making adjustments to pay, making adjustments to work schedule, that you all need to focus on. And so the first question I have is, can an employer reduce the wages or number of hours of an hourly employee? And the answer is yes. If they are non-exempt, then we may reduce their hourly rate, provided it's not less than minimum wage. At the same time, we can also reduce the number of hours that they work during a given week. The employer has those rights and is able to do so. The challenge becomes a little bit more is if we are trying to change a salary or an exempt employee's salary. We're trying to reduce that. We are able to do that, but it comes with some conditions. First, we cannot reduce the employee's salary during a given week. We can only do it prospectively. We can only do it the following week, and we can reduce it then. We need to make sure that we do not reduce the salary below $684, because that's the new minimum threshold that was just recently enacted or went into effect earlier this year. Okay, and so these are the two things that we need to be mindset about. The third thing is we need to do it for a bona fide reason if we're going to make it. It can't be simply because the employee's work performance is poor. We need to make sure we have the business reason to do it, and that we are just cutting back. But when employers are cutting back the amount of time work or changing salaries, there's another problem that we might face with these exempt employees. And that is, for example, The employer, if the employer is requiring its managers, for example, to start performing more production type tasks and get away from some of the managerial duties that they are traditionally been performing, then all of a sudden we face a dilemma where we might lose this in-person's exemption. And the reason is because no longer is their primary duty going to be, for example, supervising employees. Their primary duty might now become, because we changed the position, to more production stuff. And if the primary duty is not the supervision of 2 or more employees for one of the exemptions, for example, then we lose the exemption, and then we have to pay this individual overtime for any time worked over 40, even though they're paid a salary. So we need to be very mindful of that. I see challenges in the future from different plaintiffs' law firms on this, because they're going to say that, you know what, I know you had, for example, a manager in the restaurant, but that manager is now doing all these different tasks that are really not an exempt type of task, okay? So if we're worried about this, if we're worried about changing the pay structure of these, changing the duties of these managers, for example, what can we do? We can do 2 things. One, we can just make them to hourly, and that way we don't have to worry about it. If they work over 40, we just have to pay them overtime for that time. Now, if we don't want to do anything, we think we're pretty safe, I do recommend that you have these managers start recording their time. I don't want a situation where we never recorded their time, we don't know how much time they worked, and then all of a sudden we have the employee later file a lawsuit and says, good gosh, I was working 60, 70 hours a week. And we have nothing to show that that's incorrect. But if they were recording their time, maybe we can show that it was only 50 hours, or maybe it was 45 or something like that, which substantially reduce the amount of liability that there is. Now, I don't know if there's any restaurants or if there's any other businesses, companies on the phone today or attending this webinar, but some of these businesses, as we're talked about even during, before the presentation started, have gone to a more delivery basis. And I want to make sure if your business needs to perform more deliveries, there's 2 things we need to make sure that we're doing. One is you need to call immediately your insurance company to make sure that these drivers are insured, or that the company is insured when handling this. Good gosh, if they were to get in a wreck or something like that, I don't want to get the company exposed to substantial liability. The second thing that you need to be mindful of is, how are these employees that are performing these deliveries, how are they getting reimbursed for the vehicle costs that they're incurring for making these deliveries? My firm has been involved in several lawsuits over the years where companies' reimbursement policies might have been insufficient, at least in the eyes of the plaintiff's attorneys. And what they're saying is that if you are being paid minimum wage or just slightly above minimum wage, and the cost incurred for driving your vehicle is in excess of the minimum wage, meaning it would cut into your minimum wage, then you are liable, and the employer will then be facing a lawsuit. I encourage employers to really try to pay the IRS rate or close to it if they're paying on a per mileage basis. If you're doing a delivery fee and not really doing it on a per mile basis, make sure you do the calculations. Make sure you do the math to determine what that really constitutes on a per mile basis, because you want to make sure it's still close to the IRS rate. Now, there's no guidance or law that requires an employer to pay the IRS rate, but it needs to be pretty close to it from all of the cases that we've seen, and I can offline go into that way more in detail for you. Also, if your organization has tipped employees, you need to make sure 2 things given the times. One, make sure that if you're paying them the sub-minimum wage, that their tips are at least accounting for them or making them up to the minimum wage. We just need to be mindful of that, because there's probably a reduction in tips for the services that are being performed at this time. And second, if you have a tip pool, make sure managers are not, dipping their hands in the tip pool. The last thing I want to see is that, because when managers are being able to get tips from the tip pool, it eliminates the tip pool and we have some problems. Okay. So now let's assume that we've done our best in trying to modify our operations. We explored the ability to make pay cuts. We've explored the ability of, modifying the schedules, but now we have to consider whether we are going to do a layoff or a furlough. Okay. And let's talk about the differences of the two. Furlough is, generally speaking, when you take an employee off of the schedule for a period of time with the expectation that you're going to bring back that employee. A layoff is a little different, is actually when you're letting the employee go. You are breaking the employer-employee relationship. Now with the furlough, you might not be able to bring them back, and that's okay. But right now, you at least have that expectation that if the times get better, if we get through this stuff, then you're going to bring them back. And that's an important difference, because when you're looking at furlough and layoff, you actually want to side, in my opinion, you want to err more on the furlough as opposed to layoff. The reason being is that it's a lot easier to bring someone back who has been furloughed. You don't have to go through the I-9 process. You don't have to go through the onboarding process, and allows the employee to know that you're still, you still want them. You still want them to be part of the team. You just, unfortunately, right now, you just can't schedule them for any work. I do believe it's very important that you communicate this message to the employees. Again, let them know that they're not fired, that you're not letting them go, that we just can't give them the hours, okay? So the next logical question then is if an employee is furloughed, are they entitled to their PTO time, for example? Or what about their sick leave? And they're going to ask, can I use this PTO time or sick leave to kind of, time you over until you start scheduling me for hours? Well, the answer to that question is that it really depends on your company's policies and practices. If you have a policy or practice that pays an individual when you lay someone off, then all of his or her accrued PTO time would be due to that employee. But if you furlough them, you probably don't have a policy or practice on how you need to address a situation. Therefore, you should be entitled to say that our practice is going to be what I'm not going, that our practice is going to be, that I'm not going to allow you to take your PTO time at this time. The company is in the process, for example, of trying to protect its cash position, and you simply just cannot pay it out. Now, this will change once you make the decision that you have to entirely break the employer-employee relationship. And when you do that, when you break that relationship, and you have a policy that needs to pay it out, then you'd be responsible for paying out that time. Now, what about health insurance benefits for when you furlough an employee? Well, if you have health insurance policy, you're typically, your employees are paying at least a portion of their premiums. But what happens if they're no longer receiving that paycheck because you're not scheduling them for any hours to work? In that circumstance, I would point everyone to the Family Medical Leave Act. What we generally do under the FMLA leave is that while an employee is out on unpaid leave, the employee is generally responsible for still making payments, his or her payments, for the premium. Now, sometimes when this happens, the employer will go ahead and make the contributions on behalf of the employee's behalf. And if they do that, they can, when the employee returns, they can work out an arrangement with the employer that they will reimburse them for the premiums that they paid. Or some employers actually just forgive it, but generally that's how it goes. But the problem becomes, though, is if when they come back, they're not going to be able to make that prepayment, or they're not going to make it, and you just don't have the funds to make that payment for them, then there's probably going to be a qualifying event where the employer is then going to have to provide this employee with COBRA notice. That way the employee knows that they want to continue on this policy, that they're going to have to go ahead and pay their premiums. Before you do this, though, I do advise everyone to reach out to their insurance agent to discuss. I know several companies recently have extended the grace periods for not payment. And so we need to look into that with these trying times. I'm hoping more and more of these insurance companies do extend them to give some more flexibility. Same thing happens also, what we just talked about, is if you reduce the schedule to 30 hours as opposed to 40. Some policies require employees to be eligible that they have to work at least 30 hours of time. Okay. And again, if it's not, and if that's a qualifying reason, then we have to again provide the COBRA notice. And usually under COBRA, you have 14 days from that qualifying event to provide the notice to the employee. Then the employee has 60 days to decide whether they or not they want to continue the coverage. And a lot of times they do, because it's still cheaper for them to get coverage through COBRA than it would be if they went out and got it on their own. So what about unemployment? That would be the next question of anybody that's, you know, getting furloughed or has a substantially reduction in work hours. Are they eligible for unemployment? In Florida, the answer is yes on both of those. So if they're furloughed, yes, they're eligible for unemployment during that time. If there's a substantial reduction in the hours worked, they are also eligible for unemployment benefits. Now, if there's a substantial reduction in the hours worked, the maximum benefit that they can receive is $275 a week. And the Department of Economic Opportunity will use a formula to try to calculate what is owed to these employees. So if the maximum benefit is $275 a week, they will get the difference of that between and what they're making, which I think is like, you know, 8 times the minimum wage. So they'll get some portion of it, but it will not exceed $275 if they have a reduced schedule. And we will talk about, and recently, obviously, as everyone may or may not know, there has been some changes to the unemployment now, especially in Florida, where now we are forgoing the requirement for employees to go out and seek, you know, look for other jobs. There was a requirement that every 2 weeks that they had to come in and say that they've talked to, or every week they've had to talk to 5 employers and try to get some business. Well, we're relaxing that requirement on what's going on. There is the thing, we'll talk about it later down the road, the CARES Act. And the CARES Act is now allowing employers to get another $600 on top of that benefit to make up some time. And I'm sorry I missed some questions, but now my chat's working here. So let's see what's considered a substantial reduction in hours. That's a great question. You know, the guidance is not, there's not a set formula. It's not, for example, it's not going to be, you know, if you just hit 5 hours less or 10 hours less. No, it's a good percentage. I would recommend if it's 40-hour shift and someone's getting down to like 25, they're going to meet that, and they're going to get a small portion of unemployment benefits for that. Now, regarding the unemployment compensation, I mean, I know I attended a seminar yesterday with Debbie Lundberg, and during that seminar, some individuals were asking, you know, is there going to be a delay on getting unemployment compensation? What are the challenges that your employees are facing? There is right now, they're trying to get rid of it in the delay, but unfortunately, Florida's scrambling, quite honestly. I read an article just this morning that for benefit week ending March 21st, there was 74,000 Floridians who applied for unemployment. And just last week, there was 200,000 additional more people that applied. So each week, it's expanding. You're getting more and more people are getting, unfortunately, laid off, substantial reduction in the number of hours, and therefore are going to be going on unemployment. As I previously alluded to, that 2.2 trillion federal stimulus, also known as the CARES Act, is going to provide employees an additional $600 a week for 4 months to people who qualify for this jobless benefit. On that $600, that is going to be something that's going to be funded by the federal government, and that obligation will not fall on the employer when that comes. But assuming now that we can't continue to employ this individual, we can't furlough them, and we need to actually just break ties, we need to lay off, then we need to talk about one additional concern that could cause. And that main concern is the WARN Act. Now, a lot of you guys this might not apply to you, so I will go brief on it. But the WARN Act is called the Worker Adjustment and Retraining Act. It typically applies when we have a plant closing or a mass layoff of employees. And so it generally applies if you are a covered employer, or if you have a covered plant closing or mass layoff. So let's briefly talk about what that means. The first thing is There was one question I can go back from Ashley. What if we are still paying a small portion of our employees' normal paycheck? Could they still qualify for unemployment? The answer is yes, because they're not getting what they normally would get. Yes, they would be able to try to seek some of the partial unemployment benefits that the state will have to offer. But going back to the WARN Act now, this applies for employers that have 100 or more employees, not counting part-time workers, and 100 or more employees of any type. Okay, and so if you don't fall under this requirement, then you don't have to worry about it. If you do, we need to worry a little bit about it, because the WARN Act requires you to provide notice when there's a plant closing or a mass layoff. Okay, and if you fail to provide notice when there's a mass closing or plant layoff, you can be responsible for having to pay your employees damages up for a daily salary and or wages for up for a period of time. Okay, and generally that notice needs to be provided 60 days before there is a mass layoff or there is or closing of the plant. Now, obviously in today's world, we wouldn't have 60 days, because that 60 days, I mean, with everything that's going on, and unfortunately some employers just don't have that luxury. Okay, and so what we need to do is there's an exemption to this, and that exemption is called the unforeseeable business circumstances. And what this does is we could not anticipate that this was going to happen. It did, and now because there was a sudden, dramatic, or unexpected action or condition outside of the employer's control, that we have no choice but to lay off. So if we know now that in 2 weeks we're going to have to lay off everybody, then we need to provide this notice. We need to make sure we have all the documentation in order. But again, if you are a company that has 100 or more employees, you are going to shut down a plant, or you're going to do a mass layoff, and mass layoff is 50 or more employees at a work site. Please call myself or another labor and employment attorney to walk you through those steps, because I don't want anybody to miss out on that, because like I said, it can be very expensive for the employer if there's any screw ups. So let's go down to the what I think everyone's been really dealing with and trying to get more information about, and that is the Families First Coronavirus Response Act. Now, this act was just recently implemented. It actually, all of it goes into effect today. I don't know why they chose April 1st on April Fool's Day, but they did, okay? And so this is when, as the employers, we need to be mindful of that and who it applies to. So let's go through some of the stuff. Now, my firm has put together a quick guide that explains this. I'm happy to email you all a copy of it. That way you have it as a good handy resource. It's also on my firm's website if you want to look at it. And the chart, I broke it up, so don't worry if you can't see it here. The chart really kind of gives you that quick reference guide, okay? So the first thing under the act is let's talk about the first thing. Let's talk about the Emergency Paid Sick Leave Act, okay? Now, the Emergency Paid Sick Leave Act, there's 6 qualifying reasons that allows an employee to be eligible for this benefit. And this benefit applies to employers that have 500 or less employees. I do not know why they designed it this way. I have no idea why they capped it at 500 and why they didn't apply it to larger corporations or larger businesses that have more than 500. You would think they would have the deeper pockets and would be able to really provide this benefit to employees. But here are the reasons that you can qualify for emergency paid sick leave, okay? The first one is employee is subject to federal, state, or local quarantine or isolation order. So the employee will have to be, that's very limited situation where the state is actually, or federal government is actually quarantining this individual. The second one is a little broader, but it's very applicable. And that is when the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Okay, and the key word here is healthcare provider. It's not them just thinking that they need to self-quarantine or want to self-quarantine, it needs to be through the advice of the healthcare provider. So that's the difference between number 1 and 2. The second one, it's a little trickier, okay? It says employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. So that is an employee who is experiencing the symptoms of a cough, a fever, or shortness of breath, and they have already gone to a doctor, or they're about to go to a doctor, and they're just waiting for their test results. In this situation, I think we just kind of have to accept what the employee is stating at this time. I don't think we want to be in a situation where, we deny the leave based on employee saying that they have all the symptoms and have sought medical leave or going to seek, a medical diagnosis. I think we just kind of allow them to apply. Groups 4, 5, and 6 are a little different. These are when the employee is actually caring for someone, the individual who is subject to an order that's designated number 1 or 2, or they're caring for the son or daughter if the school or place of care of the son or daughter has been closed. 4 and 5 are different than 1, 2, and 3. And it's important that you all see that, because when we're talking about it, it changes what they're owed, okay? So let's go through it. So if they meet a qualifying reason, then they are entitled to 80 hours if they're a full-time employee. And a full-time employee under this bill, under this act, is a 40-hour-a-week employee, okay? If they're a part-time employee, then how we determine how much leave they're entitled is we take the average number of hours that the employee generally works over a 2-week period, okay? So if they qualify for reasons 1, 2, and 3, then we need to pay the employee the regular rate of pay times the number of hours worked. Now, if an employee typically works 50 hours a week, he or she would be entitled to receive 50 hours the first week and only 30 hours the second week. The employer is not responsible for paying any overtime on that 50 hours in that week. Now, each of these benefits for 1, 2, or 3 cannot exceed $511 per day, or the aggregate of $5,110. Now, if you're a qualified employee for reasons 4, 5, and 6, and I do apologize, I skipped 6, but 6 is kind of like a catch-all. There's not going to be much there. It's really 4 or 5 that you're going to see in your workplace. So those are the ones that we're going to focus on. If you are qualified reason for 4 or 5, then we're going to receive 2/3 of your regular rate, which is capped at $200 a day. Okay. So again, the covered employees, or anybody that's, for our purposes, anybody under 500 employees, and to be eligible is any employee that's covered by the employer is immediately eligible. That even includes people that just started working for you all 2 weeks ago. All right, now this is the emergency sick pay. Now let's talk about the expansion to the Federal Family Medical Leave Act. Now the expansion applies, which is kind of unique. It applies to employers that have less than 50. As you all probably know, the Family Medical Leave Act only generally applies to people or companies that have 50 or more employees. But this is an exception to that, and this is the one that came out. And under this exception, it gives an employee the limited, for employers that have less than 50, for the limited exception, you can give them FMLA leave if their employee is caring for a son or daughter if the school or place of care of the son or daughter has been closed. Okay? If they meet this definition, which is very similar, by the way, to definition number 4 under the paid sick leave. If you meet this definition, then that employee is entitled up to 12 weeks of FMLA leave. The first 10 days of FMLA leave are unpaid. However, the employee can substitute his or her accrued paid leave for these 10 days, or they can use the emergency sick pay leave that they were entitled to under the other act. If they use their emergency sick pay leave, for example, under the act, then they are going to be paid for the entire 12 weeks that they're out. Okay. If the employee is using it, and in this case though, the employee, again, it's 2/3 of the regular rate of pay, which is consistent with the Emergency Paid Sick Leave Act, okay? And again, guys, this applies to employers with fewer than 500 employees, where it's at, which is exception to the normal rule. Because if an individual, if an individual came to you with some type of medical condition that prevented them from work outside of the coronavirus or something like that, and were unable to work, you as the employer who has less than 50 would not have to provide them any FMLA leave. Okay, so let's go through some of these questions because because unfortunately now, not unfortunately, fortunately I should say, the regulations have just been developing. We're getting more and more answers to different questions that you all have. Before I open up to Q&A, I think it's important to go through some of them. And one is, and I know some of the smaller businesses are going to be asking, is there an exception for small businesses here? And the answer is that yes, there is an exception or exemption, I'm sorry, for small businesses with less than 50. But to qualify, a business must demonstrate that when complying with the provisions of this act, it would result in the business's expenses and financial obligations to exceed available business revenues and cause business to cease operating at a minimum capacity. Or the business could say that the absence of this employee would entail a substantial risk to the financial health or operational capabilities of the business, okay? And or lastly, there are not sufficient workers that are available to be able to perform these tasks, and we need this employee, okay? Again, this really will only come up when they're under the expansion for the FMLA leave, when someone is seeking time to care for a son, daughter, or child. Now, another question that I think is often come, and I've asked, a lot of my clients have been asking about it, are employees eligible for tax credits for complying with the act? And the answer is yes. You are eligible for reimbursement of the cost of the leave, the refundable tax credits. If you intend to claim a tax credit, you will need to retain appropriate documentation. I advise and suggest everyone go to the IRS website. The IRS just today released some information about what needs to be documented, and employers must, need to follow that advice. So what documentation is that? Well, one, you need to apply the employee's name, the dates for the leave is being requested, a statement regarding the reason for the leave, and a statement that the employee is unable to work, including telemarketing. Now, just a statement alone, it might not be sufficient. Sometimes an employer will require additional certification. For example, if a child care or school has closed, you can require the employee to provide a notice that they've received that does support their story that their child care facility has closed. Now, one question that I think is oftentimes is if you have two employees, or if you have a couple and they both are a working couple and they both have their kids at home, can both of them simultaneously use this paid FMLA leave expansion to not work and still receive a pay? Well, the IRS in its publication this morning came back out and said, you know what, the employer is entitled to get a statement from the employee saying that no other person will be providing care for the child during the period for which the employee is receiving this leave. So you can get that, you need to get that statement. So if they have coverage, for example, if I need to stay home and my wife needs to work, I need to be able to make that certification in writing. Now, if the child is over 14 years old and during daylight hours, then they also need a statement from the employee showing why their special circumstances warrant why the employee needs to provide care during that time. Another question that I think you guys might have is, may the employee take the leave intermittently? And the answer is yes, but only if you allow it. Okay, so you, the employer, have to be able to agree. You have to agree to allow the employee to take this leave intermittently. Now, if you closed your business before April 1st, 2020, are you entitled to pay these employees sick leave or provide them the expanded FMLA leave coverage? The answer is no. If you sent your employees home and stopped paying them, they cannot claim they are entitled to sick leave. And this is true whether you close your business for lack of business because of the coronavirus or for some other reason. But what happens if you close your business after today? Will the employee still get his or her paid sick leave? Again, the answer is no. These laws are not designed to give these employees any additional benefits. What I mean by that is if you close your business, they're not entitled to that. They're entitled to just what they would be if they were continuing to work for your business, if they did not have to use the benefits provided in this act. So that means that those employees could then go seek unemployment compensation. Same thing as if you furlough an employee, they would not be entitled to their paid sick leave. They would have to go through their unemployment compensation. Another question that I've been asked, just as asked this morning, and I know I'm kind of skipping around, but I just think there's so many different scenarios, is one, if someone goes out on the expanded FMLA leave and is getting paid 2/3 their regular rate of pay, can that employee then use his or her PTO to cover that other 1/3? Okay, and the answer to that question is no, unless you, the employer, agree to provide it. So you guys get to make the decision on that, whether or not they're going to be able to use it and get their full rate. You know, from what we talked about before, it's going to be hard for an employer, if they're already furloughing, to all of a sudden then try to, I mean, if they're already reducing their hours, to you know, make that payment. But that's something you guys need to consider. I think it's probably a good point in time now to open up to questions. I know there's a lot of questions that you all might have. Some of them might be based on the factual circumstances that your business, or might be unique to your business, and we have to apply it, the facts to them. That's fine. I'm happy to answer any questions you have now, or I'm able to get on the phone and talk to you offline individually about the circumstances that you're all facing. So please let me know.
All right, I'll go ahead and stop the recording, and then we will unmute the group. So just please keep in mind that you are in an open forum. So we recommend that you please mute yourself, and then you can unmute if you have a question. We found that yesterday the best way to get through a full group was if you have a question to raise your hand and then unmute, and Chris can call you by name and then unmute you. But thank you so much to Chris. Thank you so much to Johnson Jackson. We're so thankful for your partnership and for this information you provided today. I'm going to go ahead and end the recording now, and we'll have this information up on the website for you later today.